Introduction and why the July 2026 bulletin is important. There is something extremely important inside the July 2026 Visa Bulletin that many green card applicants might overlook at first glance. On the surface, it appears to be just another monthly update filled with dates, categories, charts, and numbers. But when you examine it carefully, this bulletin is actually telling two very different stories. For some applicants, this update brings forward movement, reassurance, and a small yet meaningful step ahead. For others, especially in certain employment-based categories, this bulletin carries a serious caution. Your category may not simply be delayed, it may be temporarily unavailable. And this is where many people misunderstand the situation. They hear someone say, "The Visa Bulletin moved forward," and they immediately assume their own case is advancing as well. But the reality is, your result depends on your exact category, your country of chargeability, your priority date, and whether you are reviewing the final action dates chart or the dates for filing chart. One family category may progress while another employment category may completely close for the rest of the fiscal year. So before you celebrate or before you become concerned, you need to clearly determine where your case stands. Today we are going to carefully review the July 2026 Visa Bulletin in a clear and simple way. We will explain which categories saw positive changes, which categories faced setbacks, and which applicants need to be especially careful before reaching conclusions. We will review family-based cases, employment-based cases, India, China, Mexico, the Philippines, and even DV lottery applicants, because this bulletin is not just about movement, it is also about indicators for the coming months. What makes this bulletin particularly important is that the government is not only shifting dates, it is also issuing signals. Some categories advanced, some stayed the same, some retrogressed, and some became unavailable. That means this is not simply a routine monthly update. It is a clear sign of increasing demand as the fiscal year approaches its end. One small letter in this bulletin, the letter U, could completely change what an applicant should expect next. The July 2026 Visa Bulletin is not equally positive or equally negative for everyone. If you are in a family-sponsored category, particularly F1, F2B, F3, or F4, there is some forward movement. It may not be dramatic, and it may not eliminate the backlog, but in immigration terms, even a few months of advancement can be significant. It can mean applicants are closer to document review, interview scheduling, or final approval. However, the employment-based side is where the major surprise appears. While some employment categories advanced, India EB2 became unavailable. India EB5 unreserved also became unavailable. India EB1 moved backward. This means if you only follow headlines and do not check your precise category, you could misinterpret the bulletin entirely. Now let us discuss the family-based side. In the F1 category, which covers unmarried sons and daughters of U.S. citizens, there was forward movement for many applicants. For all chargeability areas except those listed, and also for China and India, the final action date advanced from September 1, 2017 in June to February 1, 2018 in July. That represents meaningful advancement, especially for those who have been monitoring the bulletin month after month with limited progress. Family category movement may seem modest on paper, but when your priority date is near, even a small shift can mean the difference between waiting and advancing. If you are in F1, review your own priority date carefully, instead of relying on summaries. The F2A category, which covers spouses and unmarried children under 21 of green card holders, remains closely watched because it directly affects family reunification. In July, F2A final action dates did not show a major change compared to June for most listed areas. It is important to remember that being eligible to file a petition is not the same as being eligible to receive a green card immediately. A petition may be approved, but visa availability still depends on the bulletin. Now let us discuss F2B, which covers unmarried sons and daughters 21 or older of lawful permanent residents. This category showed forward movement for several applicants. For all chargeability areas except those listed and for China and India, the final action date advanced from September 22, 2017 to November 22, 2017. For the Philippines, it moved from April 8, 2013 to May 15, 2013. This is progress, even if it is not dramatic. The larger picture is not only about which dates moved forward. The key question is why some family categories are progressing, while certain employment categories are freezing or closing. That contrast makes the July bulletin especially notable. The F3 category, covering married sons and daughters of U.S. citizens, also shows forward movement for all chargeability areas except those listed, China and India. The date advanced from February 15, 2012 to April 15, 2012. Mexico moved from May 1, 2001 to June 1, 2001. The Philippines moved from November 22, 2005 to February 22, 2006. For families waiting in this category, this is encouraging, but it also highlights how extensive the backlog remains. Forward movement does not mean the backlog is resolved, it simply means the queue has advanced. If your case is not yet current, this update is positive but not an immediate approval. Looking at F4, brothers and sisters of adult U.S. citizens, this remains one of the slowest family categories. In July, there was movement for several areas. For all chargeability areas except those listed in China, the final action date advanced from November 8, 2008 to January 1, 2009. For the Philippines, it moved from July 15, 2007 to August 1, 2007. This confirms that F4 continues to move slowly, even when there is advancement. Overall, July 2026 is generally positive for several family-sponsored categories, but it is not transformative. It shows advancement, not resolution. The most important step is verifying your exact category, your country of chargeability, your priority date, and the correct chart. Turning to the employment-based side, EB1 is usually considered strong because it covers priority workers, extraordinary ability applicants, outstanding professors and researchers, and multinational executives or managers. However, in July, India EB1 moved backward from December 15, 2022 to October 15, 2022. That is retrogression. Retrogression means the line moved backward due to visa demand and annual limits. The bulletin also indicated that additional retrogression, or even unavailability, could occur if demand continues and limits are reached. India EB1 applicants should treat this as a warning sign for the remainder of the fiscal year. EB2 India is now listed as unavailable. This means visa numbers are not available for issuance in that category for the rest of fiscal year 2026. This is not slow movement or minor retrogression. It is full unavailability because the annual limit has been reached. When a category becomes unavailable, final approvals cannot move forward until visa numbers reopen. The letter U in the bulletin represents unavailability, and for India, EB2, that letter now appears. EB2 China remains at September 1, 2021, in the final action dates chart, but the bulletin cautions that demand may require retrogression or unavailability in future months. Warnings in the bulletin matter because they indicate building pressure. Reading the notes is just as important as reviewing the chart itself. EB3 presents a more positive picture. For all chargeability areas except those listed, the final action date advanced from June 1, 2024 to August 1, 2024. China EB3 advanced from August 1, 2021 to December 22, 2021. India EB3 moved from December 15, 2013 to January 1, 2014. Mexico advanced from June 1, 2024 to August 1, 2024. The Philippines remained at August 1, 2023. Although EB3 shows improvement, it varies by country. The bulletin also warns that EB3 Philippines could face retrogression or unavailability. The other workers category also advanced for most areas from February 1, 2022 to March 1, 2022. India moved from December 15, 2013 to January 1, 2014. Mexico advanced from February 1, 2022 to March 1, 2022. The Philippines moved from November 1, 2021 to December 1, 2021. China remained at April 1, 2019. There is progress, but it remains uneven. EB4 and certain religious workers advanced from July 15, 2022 to September 15, 2022 across listed areas. This is a positive shift, though it does not eliminate the backlog. Positive movement in one month does not guarantee similar movement in the next. EB5 also shows mixed results. EB5 unreserved for China advanced from September 22, 2016 to December 1, 2016. India, EB5 unreserved became unavailable. However, EB5 reserved set-aside categories, including rural, high unemployment, and infrastructure projects, remain current. It is critical to evaluate the specific EB5 category rather than grouping all EB5 cases together. For DV 2026 applicants, eligibility ends on September 30, 2026. Visa numbers may be exhausted before that date. DV cases are time-sensitive and do not carry into the next fiscal year, so applicants should ensure all required steps are completed on time. In summary, several family categories saw forward movement, including F1, F2B, F3, and F4. EB3, EB4, and EB5 China unreserved also advanced. On the other hand, India EB2 and India EB5 unreserved became unavailable, and India EB1 retrogressed. Some categories received cautionary warnings about possible future retrogression or unavailability. This bulletin presents mixed outcomes. It is neither entirely positive nor entirely negative. The most important action you can take is to verify your priority date, confirm your exact category, confirm your country of chargeability, and determine which chart applies to your case. If adjusting status inside the United States, always review USCIS monthly chart guidance to determine which chart may be used for filing. All information shared here is for general educational purposes only and is not legal advice. Every case is unique, and if you are unsure about filing or approval timing, consult with a licensed immigration attorney before taking action.